Let's select a chairman. Any nominations? Yes? Christopher? Andrew Leung. Who seconds? EQ. Mr. Andrew Leung, do you accept? Yes? Any other nominations? If not, Andrew Leung then. Thank you for your support. Do we need a deputy chairman? No? Let's invite the administration in then. And I need to declare that I'm a member of the Competition Commission. Let's welcome the administration in, and we have with us Under Secretary Mr. Godfrey Leung, Ms. Carol Yuen, Deputy Secretary, and also Ms. Wendy Zhang, Assistant Judiciary Administrator, Mr. David Grover, Ms. Yvonne Zhang, and Mr. Francis Kwan, and Ms. Monica Law, and Mr. Raymond Wu. Under Secretary, over to you. Please walk us through the bill. Thank you, Chairman, for inviting us to this Bills Committee so that we have an opportunity to explain to members the policy considerations in drafting the Competition Amendment Bill 2014 and to assist members in scrutinizing the bill. The bill seeks to amend the Competition Ordinance CO to give powers on the tribunal and the specific powers and to ensure the operation readiness of the tribunal. The competition ordinance was enacted in June 2012. It provides a legal framework to tackle anti-competitive conduct across different sectors. And since the enactment of the competition ordinance, the administration has been working closely with the Competition Commission and the judiciary on its implementation. One of the important tasks is for the full operation of the tribunal. The Competition Tribunal is a superior court of record established under the CO, having primary jurisdiction to hear competition-related cases. And the judiciary, in a course, and the administration have identified certain amendments to the CO and consequential amendments to other pieces of legislation which provides a clearer legal basis for the operation of the tribunal. We therefore propose to amend the CO by introducing this bill. There are three major areas of this bill. The first area has to do with the proposed general powers for the functioning of the tribunal. Generally speaking, in exercising its judicial powers in respect of civil proceedings, the CFI, the Court of First Instance, is empowered to grant orders, and it has the specific powers or inherent jurisdiction. Although in granting reliefs and orders, the competition ordinance doesn't specify whether the tribunal would have such powers to grant remedies and reliefs in discharging its functions, and we therefore propose to amend the CO to confer specific powers on the tribunal, so to give greater clarity. These powers include the power to enforce the orders of the tribunal, the power to award interest on debts and damages, etc. The second area has to do with amendments relating to registrars. Now, the ordinance currently provides for a framework on the automatic appointment of the tribunal's registrar and other registrar-related positions. However, it doesn't confer powers on the tribunal's registrars who perform judicial duties as with their counterparts in the High Court, and to ease the workload of members of the tribunal and in line with the arrangements for the High Court, we propose to amend the CO to empower the tribunal's registrars to perform judicial work under the CO similar to that of their counterparts in the CO, and also to give tribunal's registrars the privileges and immunities currently enjoyed by the registrars in the High Court. We also proposed to amend the CO so that temporary registrars in the High Court would automatically hold the corresponding positions in the tribunal and be given similar powers and duties, etc., of their permanent counterparts in the tribunal. The third area is consequential amendments to other pieces of legislation, including the High Court Ordinance, the Legal Practitioners Ordinance, the Higher Rights of Audience Rules, the Evidence Ordinance, the Electronic Transactions Ordinance, and the Shenzhen Bayport Hong Kong Port Area Ordinance. These amendments aim to facilitate the future operation of the tribunal and to ensure consistency with the arrangements currently applicable to the CFI and or other courts or tribunals in general under these ordinances. These amendments are essential to the smooth operation of the tribunal. To allow the tribunal to give full play to its powers and functions, these amendments must be made, and I want to supplement in relation to the implementation of the CO. The administration, the judiciary have been working closely in relation to the implementation of the CO. The first phase related to the operation of the or its establishment of the Commission and the Tribunal. The relevant provisions came into operation on the 18th of January 2013 and the 1st of July 2013. And when the administration briefed the LegCo panel, we already said that we briefed the panel on economic development on the 16th of December 2013. The administration will continue to seek views in formulating the draft guidelines. By the end of the year, we expect to consult the public and stakeholders on the draft guidelines and to finish the work by the first half of 2015. The judiciary is formulating rules in relation and direction for judges and administrative arrangements for the operation and proceedings of the tribunal. The judiciary is expected to complete this task by the first quarter of 2015. And this Bills Committee, in relation to its work in scrutinizing this amendment bill, is very essential to the operation of the tribunal. And the work should be finished before commencement of the tribunal, and the CO will be fully implemented only after these amendments are introduced. These are technical amendments, Chairman. These don't affect the operation, penalties, investigative powers of the tribunal. The purpose is for the tribunal to enjoy the specific powers similar to those exercised by judges in the CFI in granting orders and enforcing the law. So much from me. I welcome questions from members. Any questions, Mr. Albert Chan? Chairman, I'm concerned about the operation of the tribunal and its impact and the financial burden on people of Hong Kong. There are various kinds of tribunal, for example, small claims tribunal, and it provides that no legal representatives should be present, and this helps reduce costs because when the losing party may wish to file a claim, and very often you may claim against a major or large consortium, and there is therefore a huge asymmetry of powers. So about this competition tribunal, will it be operated in a similar manner as the Labour Tribunal, the Small Claims Tribunal, or the Lands Tribunal? If it's similar to the Lands Tribunal, then it means those better off will have all the say. So can you tell us more about its operation? Mr. Aberchan, this bill involves technical amendments only. It's not about the tribunal's operation starting from scratch. We've gone through all that before it's the enactment of the ordinance. Now, of course, Chairman, I'm not very familiar with this area. Maybe our questions are ignorant. So please accept this ignorant big guy here. I don't agree. You don't agree I'm ignorant or what? Maybe I'll defer to my colleague from the judiciary to take your question. In brief, the tribunal's operation will be similar to the operation of the High Court and the Court of First Instance. Of course, litigants can be legally represented. If the party is a company, then with leave, company directors may also be present. As for individuals, they can come unrepresented. Now, Mr. Chan asked about costs, litigation costs, and at present, the tribunal is making internal arrangements. There will be rules relating to the competition tribunal, and these rules will be introduced into this council, and members will be briefed on the detailed operation of the tribunal. I understand members are concerned about costs, and we mentioned that as far as the operation of the tribunal is concerned, we can perhaps be more relaxed in relation to the judicial procedures so as to facilitate smaller companies and individuals. Say, for example, summary procedures can be adopted, or forms can be used, or informal forms can be used. And we will consider all the concerns of members in detail. Now, can you explain to members that this competition ordinance doesn't really target members of the public, but rather to tackle anti-competitive conduct across different sectors by larger companies, and these companies must have at least some means for them to be engaged in such conduct. Thank you, Chairman. Now, the concept of the competition ordinance is that we have the first conduct rule and the second conduct rule, and they tackle anti-competitive conduct. And only when anti-competitive conduct arises will the Competition Commission launch investigation followed by judicial proceedings in the Competition Tribunal. So if no anti-competitive conduct is involved, or if Competition Commission has not launched any investigation against any case, there will not be any proceeding in the tribunal. And only when a case is made out can this case be submitted to the tribunal. And we have also considered the concerns of the sectors. So in relation to first conduct rules and the second conduct rule, if they are not serious breaches, they will fall outside the scope of the first conduct rule and the second conduct rule. Yes, Mr. Aberchan? Please turn on the microphone.
Thank you. Thank you, Chairman, for your guidance. I'd like to clarify one more point. I was not a member of the Bills Committee, so I do not know many of the details. Regarding the proceedings, I understand that the Commission has the initiative but the bill does not rule out any members of the public to to initiate proceedings. Is there a mechanism that the proceeding must be initiated by the Commission? I think the ordinances provide for a follow-up proceeding. When the tribunal has ruled that there is an anti-competition behavior, then the members of the public can initiate follow-up actions. That is, at the initial stage, it would be for the Commission to conduct an investigation and then refer to the tribunal when prosecution is required. So, in other words, according to the mechanism, the public may initiate follow-up proceedings. So any member of the public will have an opportunity to, although it's a follow-up action, there is still the possibility that they can initiate proceedings through the tribunal. And the ruling after the tribunal has ruled that there is anti-competition behavior, the public can take follow-up action. But it is not the case that right at the beginning the public can initiate proceedings with the tribunal. Chairman, according to the bill, the deputy registrar can automatically take up the post of temporary registrar. So under what circumstances will the registrar of the High Court be asked to take up the duties of the tribunal? Will this be a standing arrangement? Suppose the tribunal has to deal with many cases, and the registrars in the tribunal will not be able to cope with the workload. Is it the case that only in such circumstances will the registrars from the High Court be transferred to the tribunal? And when the tribunal cannot recruit the necessary manpower, will the registrars from the High Court have to be all transferred to the tribunal? Would it be for the court to second registrars to do the work of the tribunal? Well, these judges already have a very heavy workload, and they have to take, and then of course the hearings for the tribunal would therefore have to be may take a long time. We understand that the implementation of the competition ordinance will will create additional workload for the judiciary. As the member pointed out, I mean, some of the cases to be handled by the tribunal could be very urgent. Therefore, at the end of 2012 and 2013, with members' permission, we've created two positions. First of all, the post of judge of the CFI, and another post for deputy registrar. After we've created these two posts, we officially appointed the officers in August last year. They are now doing the preparatory work as to how much time they will focus on the duties relating to the competition law. It's not the case that we are short on manpower, but we believe that the cases of the High Court may be related to cases involving the tribunal, and the bill also has suggested that the cases of the CFI could be transferred to the tribunal. So the practices adopted and also the powers of the two are very similar, and that's why the ordinance stipulated all registrars of CFI will automatically become the judges in the tribunal, and the registrar will also become the registrar of the tribunal. Administratively, since we already have the registrar for the tribunal, there will be a deputy registrar. We expect that the two of them will take up most of the cases relating to the competition ordinance. There might be many cases, but we don't know. But the other judges of the CFI may also help if necessary. So we will have a flexible arrangement to deploy manpower and ensure that there will be sufficient number of judges or registrars to deal with the cases. Chairman, I understand that you have the flexibility in deploying judges, but we all know that in Hong Kong, and I read from the newspapers that the cases in court have to take a long time to be brought to trial. there are many SMEs who have indicated to us that they don't understand the proposal, and very often with this lack of understanding they have been asked to the court to explain their case. If you have many such situations, then there will be long queues, a backlog of cases for the tribunal. Of course, sometimes there is a transfer mechanism, but in case you have huge backlog of cases, for an SME, I mean, if the case is pending for a long time, then the business will be adversely affected. So I understand that you have already created several posts, and the officers already, have already been appointed. But there are still many ambiguities in the guidelines. But in case the case is brought to the court, and if there's a long delay, it will adversely affect the businesses of the SMEs. So is there any way you can resolve this problem? Could the Permanent Secretary first answer the question regarding manpower deployment, and then Ms. Cheung can follow. Thank you. I'd also like to thank Mr. Jeffrey Lam for the question. The competition ordinance was enacted in 2012. Before that, in the Bills Committee, there was a lot of discussion, because all members understand that the competition ordinance is a brand new ordinance and a very important one. We understand that the trade, especially the SMEs, have many concerns. So at that time, in respect of the concerns of the SMEs and to better prepare for the implementation of the ordinance, we've done a lot of preparation. First of all, if we want to help the trade better understand the ordinance, we felt that at the first and second stage, during the preparation work, the Commission will have to explain clearly to the trade that what the ordinance includes and how it should be interpreted. And that's why this year the competition will be drafting some guidelines to consult the trade. And secondly, in the ordinance, in order to help the trade understand the ordinance and to help them better prepare themselves, we've done several things. First of all, we've clearly defined what is meant by serious breaches of competition. So to help the trade better understand the provisions of the ordinance. And secondly, it's not that all anti-competition behavior will be brought to the tribunal. If we have reasons to believe that even if the entity has breached the Code 1 rule, then the tribunal can issue warnings and set a guideline for the entity to cease such anti-competitive behavior. So the case will not need to be brought to the tribunal. We've also have agreements of behavior with less impact. If you have agreements and behavior with a lesser impact, again, these will not be. If these are not serious breaches of the anti-competition ordinance, then these cases will not be brought to trial in the tribunal. So as far as the workload of the tribunal is concerned and how the SMEs can comply with this ordinance, this will certainly help. So when we designed the bill and when the bill was enacted, we had already, actually this was the outcome of our discussion with the trade. Regarding the actual operation of the tribunal, Ms. Cheung will further supplement. Members are concerned about the scheduling of trials. Over the past year or so, our chief registrar and registrar have visited the UK, the European Union, and Australia, and found out that many of these cases involving the competition ordinance could be scheduled for trial very quickly. So these two registrars, these two judges, the chief registrar and the deputy registrar, will give priority to cases involving the competition ordinance. If there is an urgent case, then they may refer some of the cases to other judges in the High Court so that they can deal with the case of the tribunal. We also have a deputy tribunal assistant registrar. So in case when there are rules involving the competition law and when there are directions from the Chief Registrar, a presentation will be arranged. And if there are still lack of understanding of details, and they can inquire with the registrar. So we understand that for some period of time we need the court to give more guidelines and explain the steps that the court will take. So we certainly take on board the concerns of members. Ronnie Ton. When I heard members' questions and the administration's response, after I've heard that, I'd like to clarify further on the question of the structure and and resources of the tribunal. First of all, is it the case that you already now have a permanent judge, Mr. Lam, Justice Lam, Godfrey Lam, Mr. Justice Godfrey Lam, who has already been appointed by the Chief Justice as the Chief Registrar of the tribunal? You mentioned there will be another judge assisting Justice Lam. So is it the case that we now have two judges, sitting on the tribunal? And secondly, regarding the workload distribution, it will depend on the Chief Justice. Depending on the workload, he has the authority to instruct other judges to also sit on the competition tribunal. Do we need to deal with that through legislation, or is it is it purely an administrative arrangement? And secondly, pardon my my ignorance of some of the terms used. What do you mean by registrar? Are you referring to the masters or the registrars? My understanding is that the function of the tribunal is not that of a civil court. It's more, its function is more like that of a criminal court. Since its function is similar to those of a criminal court, if you talk about masters, for civil cases, the procedure for preliminary hearing is even more cumbersome and complex. So I understand that in a criminal court, the so-called the workload that has to be undertaken by the registrar is not that heavy. Especially in this ordinance, we have said that the Competition Commission will first conduct an investigation. After the Commission has conducted an investigation and come to a conclusion that there is a need for prosecution, only then will the case be referred to the tribunal. So there's a lot of preparation which should have already been done at the investigation stage by the Competition Commission. So the work of the registrar, so how much will be the workload of this registrar? And secondly, well, that's my first question. And secondly, if you could also deploy the deputy registrar to the tribunal, I will be a bit worried, because the tribunal is kind of a specialist court, and the laws that they have to quote and the procedures they adopt are different from the procedures in a civil court. Allowing deputy registrars or temporary registrars to deal with the work of the tribunal, would that be appropriate? Or do we need to consider in the long run to appoint permanent registrars to deal with the preparatory work before trial? Thank you.
Mr. Cheung, I'll try my best to answer all your questions. I hope I will not miss out anyone. Apart from Mr. Justice Godfrey Lam, we're considering whether any other judges can be deployed. And last August, we appointed Mr. Justice Godfrey Lam, and for the Deputy Registrar, we appointed Madam Justice Queenie Au Yeung. And I actually have meetings with these two judges every day at this preparation stage, and we also talked about the Deputy Registrar and a master with the surname Hui will be responsible for it. So basically, these are the 3 judicial officers involved, but in the future, the competition ordinance provides that all High Court judges will be automatically appointed as judges for the tribunal. And let's say if there's a case overload, then without amending the law, the tribunal's registrar will have the power to deploy judges to take up these cases. And as far as training is concerned, we need training to help judges familiarize themselves with the CO, and the training will not just involve these 2 judges, because in the future, if more judges are needed, we can immediately deploy more judges to the tribunal. So we'll also accord priority to some urgent cases. As for the difference between a registrar and a master, and what is the difference? So, registrar, that's for the judicial proceedings, and master is the other term, because there are 4 posts. The path is like this. Is the registrar, senior registrar, deputy registrar, and temporary registrar. So for the 3 ranks below, we just call them masters. So our idea is that for registrars and masters, they should enjoy similar judicial powers. And the member also mentioned criminal proceedings. Maybe I'll defer to my DOJ colleague to explain about it. This tribunal is a court of law as well. As for temporary registrars, we will appoint temporary registrars. I think members will understand that some serving judges now will act as temporary registrars on a 3-month basis, and they are normally practicing barristers. And for temporary registrars, we need to appoint temporary registrars just like acting arrangement for civil servants, to see if the judicial officers are suitable for this post, and we therefore have temporary registrars, and altogether there are around 10 of them. Some of them are titled, carry the title temporary. It doesn't mean that they only work on a temporary basis. This is sort of an acting arrangement for us to assess their abilities, and this is rather an area that requires in-depth knowledge, legal knowledge, and some commercial conflicts may be involved. It may not be suitable to deploy really outsiders. And we will try our best to deploy internal judicial officers, and yet this post is called temporary. Now, let me follow up on the question of a long list of cases. Actually, there aren't many cases, but these cases may take a long time, because from overseas experience, the hearing of a case may take up to 3 or 4 years. So that judge will be engaged in the hearing of one particular case and not others at a time. As for the registrar, he can deal with several cases at a time. So the workload for these 2 levels of judges are different. So in considering resources for the tribunal, you should also consider this point. If a judge hears a case for 2 years, he won't be able to hear any other case. Whereas for the registrar, the nature of work is very different. Thank you for your concern. As mentioned just now, we have added a post of registrar, and also we see from overseas experience that such hearings may be quite lengthy, and if necessary we will discuss and see whether more posts are needed. And we feel at this stage that this addition should be enough. Or maybe I'll defer to my colleague who would like to supplement. Chairman, member, I'd like to clarify that this tribunal acts in a way similar to a civil court and in relation to CAP 171, in relation to the competition ordinance, this commission will not take up any cases involving criminal charge. So the tribunal will be involved in mainly civil proceedings only. For example, there may be circumstances of, say, contempt of court, and the tribunal will be empowered to deal with such offences, but not criminal charges. Now, the major functions may be to penalize the offender, and these functions are actually similar to a criminal court and a civil court. Just like the Insiders Tribunal, it's considered a civil court, but the proceedings are similar to that of a criminal court. So, and on workload, there is also a difference. There are many applications in the civil court, but not in a criminal court. Now, about the test to be adopted, I think the standard or test adopted by the tribunal will be closer to a criminal court. That is, the standard will be quite high. All right, Mr. Tan Ka-pyo. Thank you, Chairman. My first question is this. I feel that this tribunal is quite specific, and also at a tribunal similar to a small claims tribunal or the labor tribunal, they would urge parties to reach consensus rather than giving an award or making any orders. So I don't know whether, according to the guidelines, this mediation will come first. I don't know. Maybe I am ignorant. And secondly, as mentioned by Ms. Zhang, the bill seeks to amend the ordinance so that High Court judges can be deployed as temporary registrars of the tribunal to cope with the possible increase in workload. I don't know whether this is the case for any other tribunals. If not, if this is unprecedented, will it affect the operation of the Competition Commission? High Court judges, when deployed to the tribunal, will adopt a high standard of proof. For example, the requirement of evidence, and whether this will be affected. Well, I don't know, Mr. Tan Ka-pyo is just too familiar with the Labour Tribunal, but this tribunal is a superior court of record similar to the CFI, so it's not different. It's not the same as a Labour Tribunal. I don't think mediation will come first in the tribunal. Perhaps I will let Ms. Zhang answer. Thank you, Chairman. As Chairman mentioned, this tribunal is similar to the Court of First Instance. It will deal with more complex cases in the hearing the hearings will be much longer than cases heard in a labor tribunal. And we talked about summary procedures, the use of forms instead of writs in facilitating different companies of different sizes, and the similar method of the CFI will also be adopted. In fact, if necessary, of course, only when it's necessary, the tribunal will also encourage litigants to resort to mediation. And however, if at the level of the Competition Commission, we believe that the Commission has considered this option and has discussed this option, and when it reaches the tribunal stage, there is indeed fewer chances of the case being conciliated or mediated. On judges automatically appointed as temporary or registrars of the tribunal, in fact, this is not a part of this bill. It's in fact in Cap 13 and Section 135, and this amendment is about its application to temporary registrars. Now, CFI is closely connected to this tribunal, and cases have been transferred between the two before, and as a result, CFI judges can also automatically be appointed as registrars of the tribunal. So this is just a technical amendment for the convenience of deployment. Mr. Lee Cheuk-yan. Now, the concern is that judges may adopt the thinking as a High Court judge, but this is a tribunal. My question is, maybe you will streamline procedures using informal forms, but these are High Court judges. My first question is, do the cases have to be referred to the Competition Commission first before taking them to the tribunal, or can they be taken straight to the tribunal directly? Now, I'll let the Permanent Secretary to take this question first. Thank you, Chairman, and thank you, Member, for the question. You're right. On anti-competitive conduct, the Competition Commission will launch an investigation against the breaches first, and if the legal proceeding is to be initiated, it will initiate a proceeding at the tribunal to hear the anti-competitive conduct. So you have to go through the Competition Commission first, and the litigant or the applicant will fill in the form himself, and then the Competition Commission or the Competition Commission will do the job for him. Well, let her answer. Thank you, Chairman. The Competition Commission will be responsible for initiating the proceeding. So it will be done by the Commission. Will there be any legal aid available for the litigants? Permanent Secretary? Well, in fact, according to the ordinance, the Competition Commission will initiate the proceeding instead of an individual doing so. So if any anti-competitive conduct is involved, the Commission will instigate proceedings, not the individual. All right, so the Commission will do that. What about the format and the forms, etc.? They should be very familiar with it. From what I heard just now, it seems that you're worried that people may not be familiar with the proceedings and forms will be used instead. I think the Competition Commission will instigate proceedings, and yet the other party may also rely on this informal form or format in giving evidence, etc.
澄清一下咧，即係
The administration clarify the point about follow-up actions. If the Commission has conducted an investigation, and if the parties want to initiate follow-up action pursuant to Section 110 of the ordinance, well, this has to be initiated by the Commission. That is, if the Commission has conducted an investigation, will the tribunal initiate prosecution? Mr. Yun, Ms. Yun. Thank you. When there is an anti-competition behavior and the Commission has conducted an investigation and initiated proceedings with the tribunal, and after the tribunal has made a judgment, then the follow-up action could take place. That is, after a judgment has been made, it will provide another opportunity for the trade to initiate follow-up action. It will be initiated by the trade. For follow-on proceedings, they will be initiated by the trade. Well, regarding the format and the forms, it's not part of the follow-on action. Both parties can use the same form or format to initiate legal proceedings. Ms. Cheung? Yes. As mentioned earlier, in the competition ordinance, there could be different types of cases, some of which the competition will be involved, the Commission will be involved. If the counterparty is a corporation, we may not necessarily require the other party to be legally represented. For follow-on action, I believe they may involve companies of different sizes, and because of that, we want to adopt a standard approach. We provide standard forms for all the litigants, including the Commission and companies of different sizes or even individuals. We believe that by adopting an informal approach, it can facilitate the proceedings. Chairman, I think when there are informal arrangements, the parties may need help. Will you have people to help when people don't understand, for example, how to fill in the forms? And secondly, you said that you want to expedite the proceedings. Do you have any target in mind? Regarding the assistance, in the High Court, we have cases where the parties are not legally represented, and they would come to us and ask us questions about procedures and so on, and we'll try our best to assist. But the judiciary need to be independent. Especially when the provision of legal advice is involved, then the parties may need to seek assistance elsewhere. Regarding the expedition of proceedings, we visited other jurisdictions where they have established the competition law for a long time, and we've learned that in some cases, sometimes the case is not very urgent, but where there are urgent cases, it could be the whole trial could be concluded within 6 months to a year. And if this could not be done, then they will apply for, they may not be able to resolve the problem through injunctions. So depending on the case of the nature of the case, we will try to handle the case as soon as possible. As in the case of the High Court, there might be cases which has to be heard immediately. Then in the light of the circumstances, we will deal with those cases as soon as possible, because we're talking about cases involving businesses, and very often they cannot be delayed for too long because the circumstances may change. So, I mean, the cases will vary according to the complexity and so on. According to OFA's experience, there are different scenarios. There are some cases which could be very urgent, but for other cases, it may take much longer, as long as 4 years. So we will make a judgment depending on the merit of the case. We will not, we ensure that the outcome will not be affected by delaying the proceedings. Well, the bill was enacted on the 22nd of June 2012. many members were not on that Bills Committee. So they may understand that today we're discussing the technical amendments to the ordinance regarding the powers of the registrars and the restrictions of such powers and so on. It's good that we can have a discussion on these, but apparently our discussions become a bit fragmented. So it may help if members can refer back to the ordinance. Our legal advisor has worked diligently and prepared a number of questions for the administration, and they have actually written to the administration on the 30th of May. Apparently, we haven't had a response yet, or am I mistaken? I think I'll deal with these questions later on, because there are many technical issues which have been raised by the legal advisor. Okay, I'll ask the legal advisor later on to explain, and then you can save your questions until then. Now, one question I'd like to ask now is in respect of the amendment to the Legal Practitioners Ordinance. It is your view now, if I'm understanding you correctly, is that you're going to you only restrict the right of audience for solicitors and not barristers. Thank you. Over the past 2 years, we have had a new arrangement. We have solicited advocates who have, after acquiring some experience, can apply for the higher rights of audience to the court. And they will go to the Higher Rights Assessment Board. So some solicitors nowadays already have the right of audience in the High Court. So regarding the amendment to the Legal Practitioner Ordinance, it is purely a technical amendment. We've already said earlier that the status of the Competition Tribunal is very similar to the CFI. So if a solicitor has already been granted the right of audience in the High Court, then we believe that the same person should have the same right to speak on behalf of his clients in the tribunal. So this is purely a technical amendment. Chairman, I'm not concerned about the circumstances. Are you saying that the tribunal status is similar to that of the CFI, and therefore solicitors can also apply to the CFI for the right of audience? I'm not against applying this same mechanism to the tribunal. Maybe we've not touched on this question before. Now, since there are many cases handled by the tribunal involving commercial cases and also involving lawyers specializing in this area of law, and they may even have more experience than the barristers. If you now also want to restrict the right of audience by solicitors, and solicitors can only have the right of audience if they have obtained permission from the Higher Rights Assessment Board, then this is a concern. I don't know whether or not when the Bills Committee deliberated on the bill, have they touched on this issue. Otherwise, I believe that the lawyers don't have to wear a wig and so on. So why don't you allow solicitors to have the same right of audience, and they can only speak in the tribunal if they have obtained the right of audience in the high courts? I think it's only in this amendment ordinance. Before we propose this amendment, we've already consulted the Law Society and the Bar Association and asked them whether or not all solicitors could automatically be given the right of abuse, or should we, use the same, invoke the new mechanism, that is, solicitors who have to go through an assessment, namely they have to have 5 years experience and pass an examination before they can be granted the right of audience. Having done the consultation, the two legal bodies agree that the cases heard by the tribunal is similar to the complicated commercial cases heard by the high CFI. So therefore, they think that solicitors who want the right of audience should have the same experience, and they agree to the amendment. We have also liaised with the Higher Rights Assessment Board about this proposal, and they had no objection. But they told us that they want to extend this scheme, and when an application is made, since there are different assessment criteria, they may need to amend some of their assessment criteria in order to incorporate the expertise required. I don't know how the legal bodies responded to your consultation, but definitely not consulted its members. In hearing complicated cases, I think arbitration hearings can also be very complicated. And in arbitration hearings, both barristers and lawyers could be parties and advocates in the hearing. If their formalities are not like those of an open court, where lawyers have to, barristers have to wear wig and gown, in that case, I don't understand why solicitors, especially experienced solicitors in this field, should not be given the same right of audience. So other than the fact that the Law Society has given in so quickly, what factors have you taken in consideration? That is, why nowadays solicitors should not have the same right of audience in this tribunal. I think the scope of your question is rather broad. When the legal petition ordinance was amended recently, we had defined who are the solicitors who have the right of audience in the higher courts. But anyway, that is not within the ambit of this bill. We have now, I think all parties have agreed to the new mechanism and which we are proposing to adopt. I think to follow up on your question, we have to go back to the discussion of when this was discussed before. Well, in this present amendment exercise, you are proposing to amend the legal petition ordinance as well. So I think it's the right occasion to raise the issue. Of course, this matter can also be referred to the AJLS panel. So could you give me some sort of documents to explain your position? Our premise is that we assume that the solicitors, if they already have the right of audience in the higher court, now we believe that some of these cases could be transferred from the CFI to the tribunal. In the bill, it's possible that in a particular case, those related to competition will be referred to the tribunal. The rest of the case will be heard by the CFI. Other than the cost consideration, and to expedite the cases expeditiously, it will be best that the same group of lawyers can represent the corporations or the client, whether be it the CFI or the competition tribunal, they should have the same right of audience. Otherwise, the case will be split up into two parts, and that will help increase the costs. So the basis now is that there is this mechanism in the CFI and the High Court, and we believe that there is an advantage in extending that scheme to the tribunal. Legal advisor. Perhaps I can provide some background. When the competition bill was enacted in 2012, that ordinance does not make any reference to the subject of right of audience, except that in the ordinance, it talks about the tribunal being a superior court of records, and the administration has also explained that its composition is made up of high court judges, so its ranking or status is equivalent to that of the CFI. So if if my understanding is wrong, Ms. Cheung can correct me. I think the administration's position is that the right of audience in the High Court, I think they have this mechanism in the High Court, and they believe that for the tribunal, the same mechanism should apply in respect of the right of audience. Ranking aside, in the High Court, in chambers, solicitors now can already have the right of audience. It's not in the same as in an open court. So I think logically there should be, I understand the need for consistency, but my question is that we should try to save litigation cost, and the same team should be able to handle, different parts of the same case. So if you want to save legal costs, you should not have this restriction that only barristers can have the right of audience. And if you want to, if a case is heard first in the CFI and then referred to the tribunal, you don't want a different team of lawyers. I can understand that.
I don't know why this can justify as a reason. A legal advisor, can you further elaborate and clarify and allay Mr. Paul Chair's concerns? And as I understand, for the Court of First Instance, at present, solicitors can handle certain proceedings, for example, chamber hearings. So perhaps the administration can clarify this point about the operation of the competition tribunal. Will there be in chamber hearings, and will such judicial proceedings be similar to those in the Court of First Instance, in which the solicitors also have the rights of audience? So that means, will the operation be the tribunal of the tribunal be the same as that of the CFI in this regard? The simple answer is yes. There are two kinds of hearings: open court hearings and in-chamber hearings. At the Court of First Instance, and solicitors have the rights of audience in chamber hearings, and the same will also apply in the future. We hope to maintain consistency across these the tribunal and the CFI, and we'll also liaise with the legal sector. Let's say if the case is transferred from the court to the tribunal. Now, say solicitors may have the rights of audience at the for chamber hearings of the CFI, and they may employ the same legal team when the case is taken to the tribunal. Now, Mr. Chair is a member of the legal profession. Perhaps you are more familiar with this, and we have heard views asking for the same rights of audience to be given in the two courts, so that cases can be transferred more smoothly. So the arrangements will also be similar. Chairman, I hope you don't mind taking up more time, but this point is crucial. This is a new tribunal. Of course, it's designed to be a superior court of record similar to the CFI. But we also need to consider the consumer's perspective, litigation costs, etc. In the past, things were very clear. Now there is the gap has narrowed between solicitors and the barrister. Now, these are artificial reasons. I have the right of audience if I start off as a barrister, but not if I'm a solicitor with 8 years of experience. But now, just like the Court of First Instance, although it's similar to a CFI, the tribunal's registrar doesn't need to have the proper attire as the High Court judge. So I don't know why there is still such a huge difference. I think this has fallen outside the scope of the bill. Please discuss it at the AJSP panel. No, if I think I can object to this high rights of audience. Yes, you can submit the amendments. Perhaps I will now invite the legal advisor to explain your correspondence with the administration. Thank you, Chairman. As mentioned by Mr. Paul Chair, the we wrote to the administration asking them to clarify certain matters. Our paper number is CB bracket 11591/1314 bracket 02. The administration replied to our letter yesterday, and yesterday in the evening we circulated the papers to members. The administration's reply is paper number CB bracket 11602/1314 bracket 01. As mentioned by the member and the administration, there are points relating to the technical amendments that needs to be clarified, and the administration has by and large replied in yesterday's letter. As for other points, they will also supplement replies in writing. Now, Chairman, if you permit, I'd like to raise this point for members' consideration as a point on the policy. One of the elements of this bill is on the powers of the tribunal. When the competition ordinance was enacted in 2012, the general approach is adopted to empower the tribunal certain powers. In other words, the tribunal will be given the power similar to those of the CFI, for example, in granting orders. And all powers enjoyed by the CFI may also be enjoyed by the tribunal in granting orders. And the tribunal would have the jurisdiction and can exercise the jurisdiction similar to the CFI in exercising in civil jurisdiction. So in short, the ordinance itself has empowered the tribunal, powers enjoyed by the CFI, and about this bill, the administration considered that after passing the ordinance, whether the tribunal would have some specific powers of the CFI, and whether the tribunal can exercise these powers. And therefore, this bill seeks to provide clearly the specific powers that will be enjoyed by the tribunal. And afterwards, we wrote to the administration to express our concerns. Now, if, according to the bill, the specific powers of the CFI will be given to the tribunal explicitly, then will it affect the interpretation of the general powers in other provisions? For example, there may be specific. Now, if the specific powers are provided in specific provisions, then what about other specific powers not expressly provided in the ordinance? Now, the specific powers provided expressly in the tribunal will not affect the general powers enjoyed by the tribunal as a superior court of record. Then if this is the administration's position, they should make clear that this will not affect the existing general powers. P.S. Thank you, Chairman. Thank you, legal advisor, for the analysis. As mentioned by the legal advisor, we take a general approach in this ordinance, and this is a technical amendment. From the policy's point of view, the law seeks to provide clarity and certainty. And as mentioned by the legal advisor, in 142 and 144 of the ordinance, these two sections clearly provide that in exercising its jurisdiction, the tribunal should have powers similar to those of the CFI. However, we considered the issue and we feel that a clearer greater clarity and certainty may be given by more expressly providing the specific powers in the ordinance. For example, the powers to grant remedies and relief in discharging its functions, and also the power to award interest on debts and judgment debts, and on how interest is to be awarded. In the existing ordinance, there are uncertainties, so if we can provide a greater clarity and certainty, it will facilitate the operation of the tribunal in the future. This is our policy intent. As for the drafting of the bill, maybe I'll defer to the DOJ colleague. Yes. Ms. Law from the DOJ. The policy intent of this bill is to provide for the broad powers of the tribunal. This will not in any way restrict the broad powers. In the Land Tribunal Ordinance, for example, we see similar situations. Section 8 of the Land Tribunals Ordinance and subsection 9 states that the tribunal enjoys a jurisdiction similar to that of the CFI. And the Land Tribunal Ordinance also has other provisions to supplement the broad powers. In another section, it provides that in legal proceedings in relation to debts, etc., the tribunal may order interest on debts, and this is similar to the section 153A to be added here. And we have not in that ordinance have a specific provision to say that this does not affect the broad powers of the general powers of the Lands Tribunal. So we don't see the need to have one here, and it doesn't affect the operation of the Lands Tribunal. Legal advisor, any supplement? Thank you, Chairman. I think the Bills Committee and the administration are both very clear that the original policy intent is that the new provisions for specific powers will not affect the inherent powers of the tribunal. And this is clear. To avoid uncertainties, my question is whether you can expressly provide for such in the bill, because some provisions already provides the general powers, and for example, but if you can have a provision saying that this does not affect certain powers, so on and so forth, I think members also have experience in such specific provisions. For example, in section 143, subsection 2, 144, subsection 2, etc. I think we have such precedents before, and members may consider adding such provisions. Yes, when we come to the clause by clause, we can consider it. And on this point, I'd like to ask members, since this amendment bill is a technical one, and we've also received views from the two legal bodies, do we still need a public hearing? If not, we can commence. Well, I think this is crucial. I'd like to know the stance of the two legal bodies. Without delaying our work, I'd like to invite the relevant stakeholders to express their views. I think we need to be careful. If it's a public hearing or public consultation, sometimes, well, if we invite members of the public to come, I mean, there could be a problem. Just like at first, I allowed members to, slightly fall outside the scope of the bill, and when we invite members of the public to come, they might talk about competition in general. And in fact, the two legal bodies have already made written submissions to us. Perhaps the administration can supplement.
I was just telling members that before we consult the electoral on this bill, the judiciary has already approached the Bar Society, Law Society and the Bar. So have they given you any written submission? Yes, they are in writing. If need be, we can provide copies. Why don't you directly supply copies of those submissions to members so that members can understand and follow up on those submissions? All right, if members agree, we do not need to have a public hearing. For the technical aspects of the amendment, we can, the administration will provide copies of the submission from the Bar Association and the Law Society. Chairman, well, this morning, members who asked general questions are no longer here, and we do not have many members present. But is it the general approach that whenever a member requests for consultation, we should provide an opportunity for the consultation? I know that we're near the end of our current session, but then this is not an urgent, task. So if there is the opportunity, I think we should, protect those members who are not present and the public, so that they be given the right to be consulted. Yes, we also don't have a quorum now, and it's not possible for us to make a decision. So can we now first continue with the clause by clause, or we can ask our members to come back, or should we? Why don't we, start with the clause by clause scrutiny of the bill first? All right. I'll now defer to the administration, Mr. Wu. Thank you. I think we're looking at the marked up copy, right? Shall we use the marked up copy? Legal advisor, could you give us the reference number? We've prepared a marked up copy, that is CV1 1591 1314 (1), starting from part 2 of the bill, that is the relevant amendments. So after we've gone through the first two, members can refer to the marked up copy. Before we go to the marked up copy, Chairman, I'd like to talk about a few provisions which, first of all, the long title. The long title, Amendment to Competition Ordinance 24. But this is drafted according to the rules of procedure of the Council. The terminology provides for the aim and the scope of the bill. The long title now has already spelled out the purpose and objectives of the bill. Are there any views? Well, I don't have any particular views regarding this, but I must say that I'm not satisfied with your decision that we are not going to have a public hearing. I haven't dealt with this question yet. I don't mind you starting the clause by clause now. Never mind. Yeah, we're certainly prepared to listen to different views. What do you mean by you deal with it again? We only have 3 members present now. We don't even have a quorum to decide whether or not we should have a consultation. Well, if we don't have a quorum, why don't we simply adjourn? Shall we declare the meeting adjourned? We don't have a quorum. We can't proceed. I'd like to call a quorum. All right, will the Secretary ask members to come back to this chamber?
政府繼續。
係，多謝主席。
Chairman. You said we didn't have a quorum to deal with the issue, and now we do. We're now still doing the clause by clause. So when are you going to deal with the question as to whether or not we should consult, have a hearing? At 10:50? What do you mean by 10:50? 10:50. Thank you, Chairman. Let's continue with the scrutiny of the bill. We've just covered the long title. Next, the Part 1, Clause 1. Clause 1 provides the short title for the ordinance of the bill. Any questions? Moving on to Clause 2. This is the enactments. It provides for the enactments specified in Parts 2 and 3 are amended as set out in those two parts. Question. Next, we come to Part 2 of the amendment bill, which is the amendments to the competition ordinance. There are two broad categories of amendments. The first is to ensure that the tribunal can exercise its functions effectively and to provide it with the necessary powers, and I think we've already had some discussion on that earlier. The other type of amendments is in respect of the jurisdiction of the registrars. So perhaps I can go through Part 2 one by one with members, and members may refer to the marked up copy prepared by the Secretariat. That would be CB 159111314 bracket 1. Section 3, Clause 3 amend Section 143 by repealing a superior court of record and substituted by the court of first instance. Under Section 143 bracket 1C, the Competition Tribunal is vested powers equivalent to those of the CFI, and such powers include requiring witnesses to attend hearing, declaration, making oaths, submission of documents, and exercising orders and so on. So, in the common law, there is no clear stipulation that in the compulsory enforcement powers by the High Court, what exactly are those powers? For the sake of clarity, we propose to amend Section 143 to clearly stipulate that the tribunal, in respect of attendance by witness, submission of documents, compulsory enforcement of its orders, it enjoys the same powers as those of the CFI, the same powers and privileges. Mr. Ronnie Tong. Section 143 already provides that all the powers and privileges of the CFI should be vested with the tribunal. But we are again, also providing for, injunction from leaving Hong Kong and so on. I'd like to know whether or not there's any difference here. For the power to, restrain someone from leaving Hong Kong, the power of the CFI. I think later on we will look at 151A, B, and C. That would be an order to prohibit someone from leaving Hong Kong. We are still using 21B of the High Court Ordinance as the basis. So after the amendment, the tribunal and the CFI should have the same powers. Since you already provided for all the powers in 143, does it mean that what follows are not necessary? If you provide for the powers that follows, does it mean that they are different from all the powers provided for by 143? I think that's the question raised by legal advisor earlier. Thank you. The judiciary and administration especially the judiciary, when they drafted the rules of the tribunal, we've actually made reference to the powers of the CFI regarding the restriction of the debtors from leaving Hong Kong. We are not absolutely sure that the tribunal has that power, as in the case of the CFI, to impose an injunction restricting someone from leaving the territory, and it's because of that that we are proposing to have this specific provision saying that the tribunal in future will have that power. To answer Mr. Tong's question, I think the general provision now does not fully cover that, Chairman. Why I'm so concerned, because we're talking about not allowing someone to leave the territory. In section 143, it is already stipulated that regarding the mandatory enforcement of its order, the tribunal already has all the powers and privileges of the CFI. The mandatory enforcement of its orders must include what we'll be looking at later on under 151A, that is the payment of money or compensation and so on. So it would appear that in the mandatory enforcement of its powers, so what is said in 143 should not include 151A, B, and C, and what is included under those three provisions. Shouldn't we clarify where the line is drawn? If you say there is no difference at all, then I don't see why we need 151ABC, because the mandatory enforcement of its orders, or in principle, should cover everything mentioned in 151ABC. Mr. Wu. I think Mr. Tong has thoroughly studied the bill, obviously, but I'd like to just raise one point here. In the proposed 151A, B, and C, there are situations where under the High Court ordinance, before the CFI makes a judgment, sometimes they may also order for an injunction. And this is something which the general provision may not have covered. For the mandatory enforcement of its orders, arguably, one could say that pursuant to a general provision, this can also be covered. The general provision said that the tribunal should have the same powers like the CFI in enforcing its own orders. But rather than copying part of it, we want to, we would take the provision regarding the power of CFI and to insert it here. Perhaps I can ask our colleagues from DFJ to also supplement. If you say this, then perhaps you may need to add under 143, other than the following provisions.
To clarify this point, because if you're not sure, then if there are conflicts, then that could be problematic. Now, as pointed out just now, this amendment bill seeks to clarify the ordinance, but I think adding more ambiguities here. You should add something like subject to 151 ABC. I think this will be clearer. Do you understand? This is a point of drafting. Go back and think about it. Chairman, can I ask him? Legal advisor. Thank you, Chairman. The Legal Service Division also has the same concerns as said by Mr. Ronnie Tong. That's why we already raised this point beforehand. And we also suggest that, as we understand the policy intent, is that the new provisions will not affect the general powers given to the CFI in other provisions. So our suggestion is to make it clear that the new provisions do not confine or do not affect the operation of other provisions. In fact, in the marked up copy on page 1, you can see this similar example. In the original competition ordinance in 143 subsection 2, without limiting the scope of subsection 1. So subsection 1 talks about the general picture. Subsection 2 is more specific. So I think for the new provisions in the Blue Bill, we can also have something like what the wording in subsection 2, that is without limiting the scope of other provisions. I think the administration has heard you loud and clear, Mr. Sin Chung Kai. Also on section 143, now this Superior Court of Record will be amended. This phrase will be amended. What is the justification for making such an amendment? This tribunal is new after all. Well, these are technical amendments. The purpose is to empower the tribunal such that it enjoys powers in granting orders, etc., similar to those of the CFI. And as said in the electoral brief, after the competition ordinance was enacted, the administration and the judiciary have started preparation work. The judiciary has also commenced drafting rules for the tribunal, and this bill seeks to clarify ambiguities to ensure that the tribunal will be given such powers for smooth operation of the bill of the tribunal. Continue, please. Mr. Wu, Chairman. Yes, Mr. Sin Chung Kai. The judiciary proposed the amendment or the Competition Commission? That's my question. The amendment is not proposed by the Commission. The administration and the judiciary, having considered the issues, proposed the amendments. Mr. Wu. Perhaps we can move on to Clause 4 of the bill. Clause 4 of the bill seeks to add 151A, 151B, 151C to the ordinance. These three provisions are modeled on the section 21B of the High Court Ordinance, so that prohibition orders, as in the HCO, will also apply here. Now, in relation to prohibition order and the order to pay for expenses, etc., will be introduced for tribunal to make orders in relation to the award of damages, the payment of debts, etc. Perhaps I'll go through them one by one. Mrs. Regina Yip. Chairman, I don't have the principal ordinance, the competition ordinance here. And my question is this. Usually it's a company that contravenes the ordinance. So according to a person, who do you really mean? I can give you some possible examples. Let's say when the Competition Commission has ruled that a certain company has engaged in anti-competitive conduct, and if there are damages arising from anti-competitive conduct as such, some follow-on action can be taken. It may be taken by consumers or companies, so there is a chance that this could be a person. Now, what if, say, a company like Link REIT has been found to have breached the conduct rules, say the second conduct rule, abusing its market position, dominant position, and this person could be the CEO, is that right? Mr. Wu, Chairman, may I supplement? As I understand, or perhaps the DOJ colleagues can supplement later, I think the order is or the order here is against the natural person, not business entities. And in relation to companies, in fact, the tribunal is also powered under the ordinance, also empowered to make prohibition orders against companies in handling its own assets, or to enforce orders against companies. So this is against natural persons instead. I have a follow-up question. So depending on what conduct rule is involved, if say bid rigging, then it's simpler. Say cooked food stalls, we have had a case. What if it's a case against a large corporation? Would the responsible person of this large corporation be prohibited from departing from Hong Kong? And what redress does this person have? If this person has to leave Hong Kong, will there be any redress system for him to apply for leave from a court to leave Hong Kong? So that's my understanding. Perhaps a DOJ colleague can supplement later. For a court to give an order prohibiting departure from Hong Kong, I mean, there are constraints. As we will go through them in a moment, there will be conditions. For example, the order will be against somebody who has been found to be in breach, and that this person has been ordered to pay a specific sum of money. If the person or the company has not been found guilty, then I think perhaps the DOJ colleague can supplement whether such an order can be made against this person or the company. Any redress system? Well, in fact, in the competition ordinance specifies that any person can appeal against the tribunal's decision. Yes, anyone from DOJ to supplement, Mr. Kwan? Chairman, Mrs. Ip. Of course, if necessary, the court can prohibit the person of a certain company to leave Hong Kong. But the mechanism should ensure that the relevant authority must provide grounds or evidence to prohibit this person from leaving Hong Kong. Say, maybe this person is the sole responsible person of the company, and if this person leaves Hong Kong, payment of damages will not be possible. And in such circumstances, the tribunal will have the power to make an order prohibiting his departure from Hong Kong. So that depends on circumstances, and it depends on whether the person or the post of this person in the company or the powers of this person. Mr. Ronnie Tong. Usually, if the provision specifies a person according to Cap 1, non-natural persons like business entities will also be included. Now, I agree with what you said, but I don't think the way it is drafted can actually reflect what you say. For example, 151A3D. Okay, perhaps 151A3. The tribunal must not make a prohibition order against a person under subsection 1B unless it is satisfied that there is a probable cause for believing that. And then D, because of the circumstances mentioned in paragraph C, any judgment or order that may be given against a person, etc., etc. That is, here it says the order that may be given against a person. Say if the company has been ordered to pay compensation, and if this is a one-man band, and if this person leaves Hong Kong, the company will not pay damages. So you're going to make a prohibition order against the person from leaving Hong Kong. You can't order the company not to leave Hong Kong, of course. It must be against the person. So it looks all right until you read 1513D. Because in the case mentioned above, 151A3D can't meet the requirement because the director hasn't been found to be guilty. So if you want this provision to apply to a natural person as well as a business entity, and that you want to stop this person from leaving Hong Kong so that the court's order against the company to make compensation will not be affected, this 151A3D should be amended to cover the situation mentioned just now, to reflect what you seek to achieve. Now, Chairman, this is a technical point on whether the director should be liable for the liabilities of the company close to a criminal liability. I have reservations. In fact, if a company is found guilty, and if the director should be imprisoned as the result, there should be another set of procedures to follow. Chairman, you may recall that when we deliberated on the company's ordinance, we had this discussion. There is an extra step for the court to be satisfied that the director is the cause for this company to be in breach of the law. And this is the extra step. Now, you cannot just penalize the director and prohibit the director from leaving Hong Kong simply because you think the company has or is in breach. This is not the mechanism. If the company is required to make good the order, and then the company or the company director or shareholder should be prohibited from leaving Hong Kong, then I think there should be a safeguard here. Though the extra step is necessary, we should not take a leap and then prohibit the director. So please come back and think about this point and see how this can be dealt with. All right, this is for the administration, legal advisor. I also like to supplement. Perhaps the administration can give members more information next time for reference. I see this is drawn from Section 4 of Subsection 421, Section 21B, Subsection 4 of the High Court Ordinance. Can you give members some examples on the actual operation of this provision? Say if a company is found to have lost in a case, then can the court make an order based on the relevant provisions prohibiting the director from leaving Hong Kong? I think this is good. I think the administration can give us information on case authorities and to further explain this provision to us.
According to the administration's explanation, the tribunal, it will operate like a civil court. It's a civil court, so whether it's so easy for a civil court to impose a provisional order to ban someone from leaving Hong Kong, even the company has been found guilty, I think we must consider this. Of course, you have now, copied these provisions from the High Court Ordinance, but then we're talking about the tribunal which operates under a civil framework. So I hope the administration will go back and think about this. Thank you, Chairman, members, and the legal advisor. We'll also make reference of the actual operations of this provision when the High Court deal with such civil cases, and we'll be happy to provide, further information. Okay. Chairman. If I may go through this one by one. First of all, 151A, subsection 1, empowers the tribunal to make an order. If it is satisfied that subsection 2 and 3 of the 151A is satisfied, then it can impose a prohibition order and require the person to pay, make the payment or before he will be allowed to leave Hong Kong. The tribunal may also make a prohibition order against the person unless it is satisfied that he has dealt with the claim. So 121A 2 and 3, Virginia, 151A 3, that is the surrender of property. What does it mean? I can think of a case scenario where the company's market share is too large. One remedy is for us to divest some of its businesses. If you require the company to divest some of its assets so that its market share becomes smaller, then would it be mean surrender of property? I don't think that's what the government means. In Schedule 3 of the Competition Ordinance, according to that schedule, you'll find a number of orders that the tribunal may impose, including this. That is, if someone or a company makes a profit through anti-competition behavior, it may be required to surrender such profits, and that may involve properties. So such orders involve how such properties should be handled. So the tribunal may have pursuant to Schedule 3 make orders regarding the treatment of some properties, and as a result, the orders will need to be enforced under 151A. Chairman, does property include intellectual property? Because the first conduct rule includes, a monopoly on the technology and thus restricting competition. Would it mean that the company will be ordered to surrender certain patents? I think that would depend on the case. The ordinance doesn't provide for a definition for property. So in each case, what property the court may require the company to surrender will depend on the case. Perhaps I can provide some further information after the meeting, but at least according to the ordinance as it stands, it does not, cover intellectual properties. I think time is more or less up, and we can continue with the clause by clause at the next meeting. We now need to deal with the question whether or not we should invite deputations to express their views. Mr. Sin Chung, I think that is necessary. After we've extended the invitation, there may be no deputations coming forward, in which case we don't need to deal with it. But if we don't invite public submission, the public views, I think we will be negligent on our part. Any views? Other members? I agree. All right, we will then arrange for the public to submit views. We have to remind the public as well that we are inviting comments in respect of this particular amendment bill and not on any other subjects. Okay, we arranged for one hearing. All right? The date of the next meeting is the 30th of June at 2:30 p.m. a Thursday. We also try to arrange for the hearing to be on that day. Normally on Monday, Monday afternoon we have many meetings. like the CA panel, the IT panel, same for education panel. I think this is a very good slot. Why don't we, stick to the same slot, Secretary? The 30th of June, I think during the same slot, those meetings mentioned by Mr. Tong has not been scheduled. Of course, it would clash with the Insurance Company Amendment Bill meeting, but it doesn't clash with any other panel meetings. We have checked and we've confirmed that we can have 2 hours for that slot. But on Monday afternoons, myself and the chairman, I think we can change the schedule. Yeah, certainly. All right. So if we agree, that we will stick to the 30th of June. And with that, we are now adjourned. Thank you.